proceed from a valid piece of legislation, a valid bylaw in this case. To the extent that the law has now been struck down, the portions that are inconsistent, meaning regulating temporary shelter erected by homeless people, there is no basis for, arguably, for enforcement regulation. So it appears, at least to my eye, that there's now portions of the enforcement policy that are fine, that are valid, that continue to enforce, like safety, like digging, these sorts of things, which the ruling didn't touch. Right? But there are portions that, if the city wants to go ahead and re-regulate, create a new scheme, that's going to have to move, in my view, through a bylaw duly passed by City Council. So that's kind of the contour of the legal debate right now.
I want to just let us all know where this parks regulation bylaw came from. So I'm going to take us back 120 years to 1890. No, this is really important because you'll see when the bylaw was conceived that it had the explicit attempt not to have places for kids to play, not to have, safe places for people to, play croquet or whatever, but it was to exclude certain people from the use of public spaces. And this bylaw was passed in 1890, and in the 1930s, the exact same wording was still in force. I don't know exactly when it was changed because I'm not that far along in my research, but this is the wording of the original Parks Regulation bylaw. It shall be lawful for any police officer, constable, caretaker, or other person duly authorized by the mayor or any alderman of the city to exclude from the said public squares, parks, and grounds all drunken or filthy persons, vagrants, and notoriously bad characters, and to remove therefrom any person who is committing any nuisance or who is guilty of any disorderly conduct therein. So I just think that that's the actual law from 1890 and from 1930, and that is the historical legacy that this Parks Regulation bylaw comes from. So I just wanted to put that on the table right away. I'm not suggesting that the city is stuck in the 1890s, but anyways, some people might. Okay, secondly, I think what Ben has pointed to, and actually David Arthur Johnson in an email said this as well, that the city is basically acting, I think, in what might be called a state of exception. Now, the state of exception is theorized by an Italian theorist, Giorgio Agamben, and I'm not going to go into that. There's a book on it if you want to know more. But basically, this is when the state suspends, declares a state of emergency and suspends the rule of law. So, for example, the Canadian government can pass a War Measures Act and the army can come in and do whatever in a state of emergency, like happened with the FLQ crisis in 1970. But the local state does not have this power. This is a power that's reserved for national states. However, I would suggest that what has happened in terms of the way that the bylaw enforcement policy is being used to enforce a bylaw that Ben has showed us clearly does not exist anymore, the city is acting. They've declared an emergency. The emergency is that people are camping in Beacon Hill Park. This is a serious security threat to the city. And therefore, the city is acting in the state of exception and is basically has suspended the rule of law and is enforcing a bylaw with an enforcement policy that doesn't exist. And it is kind of, I mean, I'm being a bit funny, but it's actually not funny at all, because I think this speaks very seriously to what kinds of powers the city has and what kinds of powers it doesn't have, and how it may or may not be using those powers. So that
I was wondering if you could tell us about experiences on the street and how people have felt the city, since the decision was issued. How have they been affected? What have they been told? What do they believe? How does this affect their way of life? If you could speak for those people who have depended on temporary shelter as their home.
It's a state of confusion, how people are responding, like how the homeless are responding. We saw, the first day of evidence when they took down the tent city on the, I think it was like the 18th or 19th of October. And in the morning time, what we had was we had a mayor that was publicly announcing on CBC that they were not going to touch the tent city, that the tent city in Beacon Hill Park was safe, it was okay. And then 5 hours later, after the homeless conference where we were meeting with homeless representatives from Calgary, all of a sudden there was a rush to go back to the park. The acting mayor, Dean Fortin, at that time had ordered that the tents be taken down. The tents were taken down, but they weren't taken down willingly because people were under the understanding that the tents were okay. And what happened was these tents were taken down by the police, and there was 5 people arrested.
I'm just going to add a very brief comment, and it picks up on what Lisa raised around public spaces. And recently, someone said to me, yeah, we call this the city of gardens, but it feels like it's now becoming the city of gates. And it would be very interesting to me to look at a range of bylaws that actually impact on this same people, range of decisions. And I'll just throw out a couple of examples. If you think about things that have changed in the downtown core, if you notice the way that park benches are now structured, there's actually, they're made out of metal with a bar in the middle so people can't actually lay on them. There are metal wrought iron projectiles around planters so people can't sit. And so I think we have some serious questions to ask and answer about the way different bylaws interact and how they impact public space.